reminder, everyone, in the New York civil case, Mr. Trump was found to be fraudulent, along with Donald Trump Jr., Eric Trump, Alan Weisselberg, Jeffrey McConney. Also, the Donald Trump Revocable Trust was involved, the Trump Organization LLC, DJT Holdings Managing Member, Trump Endeavor 12 LLC. Here, the 401 North Wabash Venture LLC, Trump Old Post Office, 40 Wall Street, and Seven Springs. So they were all included as defendants, and this lawsuit was brought by the people of the state of New York, by Letitia James, the Attorney General for the state of New York. Now, this case went down in two parts, everyone. The first part was on a motion for summary judgment, which Judge Engeron ruled on, which is what I will read through this morning. And the second part was taken to trial, and we did have a civil trial in front of Judge Engeron for the last counts. So what I'm reading through today is going to be the decision and order on that motion. And again, the reason why I'm reading it is because the government's response to the dismissal, that appeal, is due tomorrow. So just kind of keeping everyone in the loop here. So, again, hopefully everything will go smoothly. I will turn on a Q&A right after I finish. So welcome in. We've got the first page here, which sets out the decision and order on the motions. You can see our index number is set out here if anyone is interested. So let me go ahead, and Judge Engeron has a very interesting way of writing his orders. He's a bit tongue-in-cheek, so we do have some a bit more humorous lines here. We have a partial summary judgment for all of the documents that were listed out above. Then we have a full summary judgment here for all of these. And then we have sanctions. So we do have sanctions for Mr. Trump's attorneys included as well. So I will start doing this live here with this order. I do plan to also do my next live to be the Trump v. Clinton case, where we also have full sanctions as well. So here we go with that. Hopefully everyone can hear me okay. It's difficult when I've got my comments off, so I apologize. All right, here we go, everyone. Let me go ahead and let me double check real quick, everyone. I just want to make sure that my volume is okay. So let me turn this on just for 1 minute. Is the volume okay, everybody? Let me just double check that before I start reading. I just got a signal that the volume wasn't working. How's the volume? Is it on? Is the volume on? Yes, volume's great. Okay, thank you so much. I will dive straight on in here. Let me go ahead and turn comments back off again. So I apologize for that, everybody. I just wanted to make sure everything was set. So just one moment. Okay, here we go. Upon the foregoing documents, it is hereby ordered that defendant's motion for summary judgment is denied. Plaintiff's motion for partial summary judgment is granted in part, and plaintiff's motion for sanctions is granted in part, as all as detailed herein. This action arises out of years-long investigation that plaintiff, the Office of the Attorney General of the State of New York, or OAG, conducted into certain business practices that the defendants engaged in from 2011 to 2021. OAG alleges that the individual and entity defendants committed repeated and persistent fraud by preparing, certifying, and submitting to lenders and insurers false and misleading financial statements, thus violating New York Executive Law, Section 63, Sub 12. Procedural background. In 2020, the AG commenced a special proceeding seeking to enforce a series of subpoenas against various named defendants and other persons and entities. This court presided over that proceeding and issued several orders compelling compliance with the AG subpoenas. During that proceeding, the AG and the Trump Organization entered into an agreement which, broadly speaking, told the statute of limitations from November 5th of 2020 through May 31st of 2022. On November 3rd of 2022, this court found preliminarily that defendants had a propensity to engage in persistent fraud by submitting false and misleading statements of financial condition, or SFCs, on behalf of the defendant, Donald Trump. Accordingly, the court granted a preliminary injunction against any further fraud and appointed the Honorable Barbara S. Jones as an independent monitor to oversee defendants' financial statements and significant asset transfers. Defendants moved to dismiss the complaint. In a decision and order dated January 6th of 2023, this court denied the motion. Defendants appealed, resulting in a January 6, 2023 order wherein the Appellate Division, First Department, modified this court's order to the extent of 1, declaring that the continuing wrong doctrine does not delay or extend the statute of limitations, 2, finding that claims are timely against defendants subject to the tolling agreement if they accrued after July 13th of 2014, and timely against defendants not subject to the tolling agreement if they accrued after February 6th of 2016, and 3, dismissing the complaint as against defendant Ivanka Trump on statute of limitation grounds, finding that she was not an employee of the Trump Organization at the time at which the parties entered into the tolling agreement. And for anyone interested in looking up that order, it is cited right here. The Appellate Division declined to dismiss any other defendants or any causes of action. Discovery ended on July 28th of 2023, and the AG filed a note of issue shortly thereafter. The AG now moves for partial summary judgment on its first cause of action for fraud under Executive Law 6312. Separately, plaintiff now moves pursuant to 22 New York Law 130-1.1 to sanction defendants for frivolous motion practice. Defendants also move for summary judgment, seeking to dismiss the complaint in its entirety. And here is the law that the judge will be referring to this entire time. So if you're wondering what law it was that was used in order to bring this suit, this is it right here. Executive Law 6312, which is a unique law here in New York. Here is the law in pertinent parts. Wherever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transaction of business, the Attorney General may apply in the name of the people of the State of New York to the Supreme Court of the State of New York on notice of 5 days for an order enjoining the continuance of such business activity or of any fraudulent or illegal acts directing restitution and damages, and in an appropriate case, canceling any certificate filed under and by virtue of the provisions of Section 440 of the former penal law or Section 130 of the general business law, and the court may award the relief applied for or such thereof as it may deem proper. The word fraud or fraudulent as used herein shall include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provisions. The term persistent fraud or illegality as used herein shall include continuance or carrying on of any fraudulent or illegal set of conduct, illegal act or conduct. The term repeated as used herein shall include repetition of any separate and distinct fraudulent or illegal act or conduct which affects more than one person. So that is the law, everyone. 6312, in case anyone ever asks what law was used, there you have it. All right, let's get into the order. Again, this is the order on summary judgment in New York in the civil fraud case. We have this up on appeal where the government's appellate brief is due tomorrow, actually. So that's why I thought we could take some time here and review the order. Defendant's motion for summary judgment on all causes of actions. Arguments defendant raises again. Standing and capacity to sue. Defendants' argument that the AG has neither capacity nor standing to sue under Executive Law 6312 and that the disclaimers of non-party accountants, Mazars, insulate defendants invoke the time loop in the film Groundhog Day. This court emphatically rejects these arguments in its preliminary injunction decision and in its dismissal decision, and the First Department affirmed both. Defendants' contention that a different procedural posture mandates a reconsideration or a fortiori, a reversal, is pure sophistry. So we've got our footnote number 1 first. Indeed, the court made crystal clear in its January 6th of 2023 order when it found, quote, "Here, the issues of capacity and standing are pure issues of law and do not depend on a trial of disputed issues of fact. Simply put, who the instant parties are and what the law says, which determine capacity and standing, are not disputed issues of fact that need to be tried." As this court and others have made abundantly clear, it's not disputed that the AG is empowered to sue for violations of Executive Law 6312. Citing case law, to be broadly worded anti-fraud device is what the law is. Here, and we're citing People v. Ford Motors. This law is the procedural route by which the Attorney General may apply to Supreme Court for an order enjoining repeated illegal or fraudulent acts. Parens patriae and consumer ambit. Defendants repeat the erroneous argument that the complaint must be dismissed because the AG cannot demonstrate the requirements of a parens patriae action, which is one of the public interest. Parens patriae is a common law standing doctrine that permits the state to commence an action to protect a public interest, like the safety, health, or welfare of its citizens. Invocation of such doctrine or its requirements is not necessary, whereas here the New York legislature has specifically empowered the Attorney General to bring such action pursuant to Executive Law 6312. Citing case law here, it is undisputed that Executive Law 6312 gives the Attorney General standing to redress liabilities recognized elsewhere in the law, expanding the scope of available remedies. Citing further case law, even apart from prevailing authority, the language of the statute itself appears to authorize a cause of action, like similar statutes that authorizes causes of action. Section 6312 defines the fraudulent conduct that it prohibits, authorizes the Attorney General to commence an action or proceeding to foreclose that conduct, and specifies the relief, including equitable relief, and the Attorney General may seek. In any event, even if the compliance with the requirements of the parens patriae doctrine is necessary, which it is not, the AG has easily satisfied those requirements, as it is well settled that, quote, "in varying contexts, courts have held that a state has quasi-sovereign interest in protecting the integrity of the marketplace." Citing case law here. Citing further case law, the claim pursuant to Executive Law 6312 constituted proper exercises of the state's regulation of businesses within its borders in the interest of securing an honest marketplace. Further case law states the state's statutory interest under 6312 encompasses the prevention of either fraudulent or illegal business activities. Misconduct that is illegal for reasons other than fraud still implicates the government's interest in guaranteeing a marketplace that adheres to standards of fairness, end quote. Defendants rehashed arguments that AG's complaint must be dismissed because it's not designed to protect consumers is unavailing. Citing Feldman, defendants claim that Section 6312 is limited to consumer protection actions is simply incorrect. The New York Attorney General has repeatedly used Section 6312 to secure relief for persons who are not consumers in cases that are not consumer protection actions. Defendants cite to the trial court decision in People v. Domino's Pizza, which is not binding on this court, as authority for the proposition that any relief sought here should come in the form of private contract litigation, not a law enforcement action under a statute designed to address public harm. However, Domino's is wholly distinguishable from the instant case. There, the court found that the AG did not establish that Domino's representations to franchises were false, deceptive, or misleading. Accordingly, the court concludes that the AG has not established that Domino's engaged in conduct that tends to deceive or creates an atmosphere conducive to fraud. Here, as discussed, infra, the AG demonstrates the defendants repeatedly submitted fraudulent financial documents to obtain financial benefits, which otherwise they would not have received. I do have footnote 2 here, so I will jump down to number 2 here. As failure to demonstrate false misrepresentation foreclosed the possibility of liability on that issue. In Domino's, any commentary about the statute's requirements was pure dicta. Dicta just means it's not actually a conclusion or a holding in the case. It's just kind of extra language that a judge threw in. So keep that in mind, everyone, that the Domino's case that's being relied on is not applicable here. Defendants glaringly misrepresent the requirements of an executive law 6312 cause of action. Citing Northern Leasing, defendants assert that the AG must show the practice is one likely to mislead a reasonable consumer acting reasonably under the circumstances. However, the word consumer does not appear anywhere in the reference decision, and the defendant's characterization of its holding is inaccurate. And then we have footnote number 3. Although consumer does appear in the first department's affirmance in the Northern Leasing case, it does not advance defendants' proposition that Executive Law 6312 actions be consumer-oriented. It simply reaffirms that the test for fraud is whether the targeted act has the capacity or tendency to deceive or creates an atmosphere conducive to fraud. The fact that Northern Leasing challenged actions targeted at consumers does not mean that Executive Law 6312 is restricted to such actions. Again, I have no doubt this will be raised in that appellate case that is where we have a brief due tomorrow. Northern Leasing confirms that the test for fraud under Executive Law 6312 is whether an act tends to deceive or creates an environment conducive to fraud. So here is our test, everyone, if you're wondering. So Northern Leasing further holds Executive Law 6312 expands fraud to encompass new liability while including non-statutory fraud claims, and finding that a claim under Executive Law 6312 is the exercise of the state's regulation of businesses within its borders in the interest of securing an honest marketplace. Non-party disclaimers. Defendants yet again argue that AG's complaint must be dismissed because the SFCs contain language provided by non-party accountants. Oh, thank you so much. Mazars that indicate that they have not audited or reviewed the accompanying financial statements and therefore cannot express an opinion as to whether the financial statements comply with generally accepted accounting principles or GAAP. However, as this court already ruled, these non-party disclaimers do not insulate defendants from liability, as they plainly state that, quote, Donald J. Trump is responsible for the preparation and fair presentation of the financial statement in accordance with accounting principles generally accepted in the United States of America, and for designing, implementing, and maintaining internal control relevant to the preparation and fair presentation of the financial statement. As this court explained in its November 3rd, 2022 decision and order, quote, the law is abundantly clear that using a disclaimer as a defense to a justifiable reliance claim requires proof that 1, the disclaimer is made sufficiently specific to the particular type of fact misrepresented or undisclosed, and 2, the alleged misrepresentations or omissions did not concern facts peculiarly within the defendant's knowledge. And then we have further case law supporting that here. The first one is the Yield Alpha Fund, where a plaintiff may not be precluded from claiming reliance on misrepresentation of facts peculiarly within the defendant's knowledge. Next is the People v. Bull Investment Group. It has been stated that the rule is clear that where one party to a transaction has superior knowledge or means of knowledge not open to both parties alike, he is under the legal obligation to speak, and his silence constitutes fraud, end quote. as the SFCs did not particularize the type of fact misrepresented or undisclosed and were unquestionably based on information peculiarly within defendants' knowledge, defendants may not rely on such purported disclaimers as a defense. In sums, the Mazars disclaimers put the onus for accuracy squarely on defendants' shoulders. Next, scienter and participation requirements. Defendants erroneously claim that Fletcher v. Dakota stands for the proposition that the purported participation element of a cause of action under Executive Law 6312 is satisfied where the defendant directed, controlled, or ratified the decision that led to plaintiff's injury. However, Fletcher is not an Executive Law 6312 action. It was brought as a corporate tort. Accordingly, it is not relevant here. And then we have footnote number 4. In fact, had defendants not cut off the beginning of the sentence they cited, it would have been evident on its face that such case is legally irrelevant, as the full sentence reads, quote, a leading treatise on corporations states that the director may be held individually liable to third parties for a corporate tort if he either participated in the tort or else directed, controlled, approved, or ratified the decision that led to the plaintiff's injury. So what the judge is doing here is finishing the rest of the citation that they put in their pleadings. However, again, so we've got number 4 here. Executive Law 6312 is much more than a mere codification of common law fraud. Defendants also incorrectly rely on Abrahami for the proposition that merely providing copies of purportedly false financial statements is insufficient. However, as Abrahami was not brought pursuant to Executive Law 6312, its analysis regarding intent to deceive is irrelevant. Unlike the situation in Abrahami, where an action is brought pursuant to Executive Law 6312, good faith or lack of fraudulent intent is not an issue. Citing further case law, holding liability under Executive Law 6312 does not require demonstrating an intent to defraud. Citing the Trump case here, fraud under Section 6312 may be established without proof of scienter or reliance. Scienter means intent. The Bull case is quoting, it is well settled that the definition of fraud under subdivision 12 of Section 63 of the Executive Law is extremely broad, and proof of scienter is not necessary. Next point here, disgorgement of profits. And of course, disgorgement is one of the huge issues that Mr. Trump brought up in his appeal. In flagrant disregard of prior orders of this court and the First Department, defendants repeat the untenable notion that disgorgement is unavailable as a matter of law in Executive Law 6312 actions. This is patently false, as defendants are, or certainly should be, aware that the Appellate Division, First Department, made it clear in this very case that we have already held that the failure to allege losses does not require dismissal of a claim for disgorgement under Executive Law 6312. Friendly reminder, everyone, in New York, we have 3 levels of courts. We have the Supreme Court, which is our trial court. Then we have the First Division, and then we have the appellates, or the Court of Appeals. So they call their court something a little bit different in New York. So this has already been appealed to the middle level. Defendants nonetheless rely on the trial court's decision in People v. Direct Revenue for the proposition that Executive Law 6312 does not authorize the general disgorgement of profits received from sources other than the public. However, defendants' neglect to mention that the direct revenue was superseded and essentially overruled in 2016 by the New York Court of Appeals in People v. Greenberg, which unequivocally held that disgorgement is an available remedy under the Martin Act and executive law. Also fatally flawed is defendants' reliance on People v. Frink, as it relies on outdated proposition that Executive Law 6312 does not create any new causes of action, and thus the remedy of disgorgement is unavailable. So what the judge is saying here is that Mr. Trump's legal team is relying on outdated law. However, in Trump Entrepreneur, in which at least 3 of the instant defendants were parties, the First Department unambiguously declared that the Attorney General is in fact authorized to bring a cause of action for fraud under Executive Law 6312. Citing case law stating holding Executive Law 6312 applies to fraudulent conduct actionable at common law as well as to conduct for which liability arises solely from the statute. Defendants incorrectly posit that under People v. Ernst, disgorgement is available under the Martin Act, but not under Executive Law 6312. That is simply untrue. In the Ernst case, the First Department specifically held that disgorgement was available and potentially crucial remedy in an Executive Law 6312 action. Defendants correctly assert and that the record is devoid of any evidence of default, breach, late payment, or any complaint of harm, and argue that as none of the recipients of the subject SFCs ever lodged a complaint with the AG or otherwise claimed damages, disgorgement, or profits would be inappropriate. Which was one of the big issues, right? They were saying nobody was harmed, so there shouldn't be any kind of disgorgement. However, that is completely irrelevant, as the Ernst and Young court noted, where, as here, there is a claim based on fraudulent activity, disgorgement may be available as an equitable remedy, notwithstanding the absence of loss to individuals or independent claims for restitution. Disgorgement is distinct from the remedy of restitution because it focuses on the gain to the wrongdoer as opposed to the loss of the victim. That is the key piece here, everyone. The law in New York says it doesn't matter if someone got hurt. What matters is that someone gained something illegally. Thus, disgorgement aims to deter wrongdoing by preventing the wrongdoer from retaining ill-gotten gains from fraudulent conduct. Accordingly, the remedy of disgorgement does not require a showing or allegation of direct losses to consumers or the public. The source of the ill-gotten gains is immaterial. So I think this is really important to remember, everyone. We have a specific citing to a case setting out what the law there is in New York. A victim is not required. All we need is someone benefiting illegally. Disgorgement is not impermissible penalty since the wrongdoer who is deprived of an illicit gain is ideally left in the position he would have been had there been no misconduct. Internal citations are omitted here, and then we have another case cited. Executive Law 6312 authorizes the Attorney General to seek injunctive or other relief, and finding the Attorney General can seek disgorgement of profits on the state's behalf. And this is page 8, by the way, of the order. So next we have sanctionable conduct for frivolous motion practice. In response to both the AG's request for a preliminary injunction and to defendants' motions to dismiss, this court rejected every one of the aforementioned arguments. In rejecting such arguments for the second time, this court cautioned that sophisticated counsel should have known better. Then we have our next footnote here, number 5. The court even went so far as to caution that the arguments were borderline frivolous. Even the first-time defendants made them. However, the court declined to impose sanctions, believing that it had made its point. Apparently, the point was not received. One would not know from reading defendants' papers that this court had already twice ruled against these arguments, called them frivolous, and twice been affirmed by the First Department. In its discretion, a court may award costs and financial sanctions against an attorney or party resulting from frivolous conduct. Citing the Cayman case, the plaintiff, following 2 prior actions, has continued to press the same patently meritless claims, most of which are now barred by the doctrine of res judicata and collateral estoppel. Defendant's conduct is reiterating these frivolous arguments is egregious. We are way beyond the point of sophisticated counsel should have known better. We are at the point of intentional and blatant disregard of controlling authority and law of the case. This court emphatically rejected these arguments, as did the First Department. Defendants' repetition of them here is indefensible. Pursuant to New York Administrative Code 130-1.1, the court, as appropriate, may make such an award of costs or impose such financial sanctions against either an attorney or a party to the litigation or both. The provision further states that, for purposes of this part, conduct is frivolous if, 1, it's completely without merit in law and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. 2, it is undertaken primarily to delay or prolong the resolution of the litigation or to harass or maliciously injure another. Or 3, it asserts material factual statements that are false. Defendants' inscrutable persistence on representing these arguments clearly satisfies the first of these 3 possible criteria. So he is saying number 1 is present. When considering imposing sanctions, among the factors the court is directed to consider is whether the conduct was continued when it became apparent or should have become apparent that the conduct was frivolous, and when such was brought to the attention of the parties or to counsel. Citing case law, further finding that sanctions both punish past conduct and they are goal-oriented in that they are useful in deterring future frivolous conduct. In its January 6th of 2023 decision and order, this court warned defendants that their reiteration of those previously rejected arguments scattered across 5 different motions to dismiss was frivolous. In a last-ditch attempt to stave off sanctions, defendants have submitted an affirmation by the Honorable Leonard Austin, who had a supremely distinguished judicial career culminating in 12 years on the Appellate Division's Second Department. Justice Austin presents what is essentially a primer on the interplay between motions to dismiss and motions for summary judgment, and every point of law is valid. However, it is wholly invalid as a reason for this court to deny sanctions. First, legal arguments are for counsel to make, not for experts to submit. The rule prohibiting experts from providing their legal opinions or conclusions is so well established that it is often deemed a basic premise or assumption of evidence law, a kind of axiomatic principle. And then citing further case laws down here, along with a Harvard Law Review, it remains black letter law that expert legal testimony is not permissible. Neither defendants nor Justice Austin had sought permission to file an amicus brief. In their own submissions, defendants have expounded on the law of capacity, standing, disclaimers, motions to dismiss, motions for summary judgment, and sanctions. The heft and prestige of a legal lion adds nothing. More importantly, the subject affirmation utterly fails to fit the specific facts of this case into the general principles it enunciates. In many situations, discovery and a complete record and the reversal of the burden of proof will turn the tide, requiring that a valid complaint be dismissed because there's no evidence to support it. But standing and capacity are legal questions, not factual issues. Crucially, while defendants have, by their own account, conducted extensive discovery and have created a complete record, they fail to point to a single fact that discovery has uncovered, let alone a single fact in the record that changes the calculus of their denied and doomed capacity and standing arguments. Capacity and standing are not esoteric concepts. Infants legally declared incompetence and persons under certain legal disabilities are not allowed to sue. The New York Attorney General is none of the above. If my sibling or neighbor is harmed, I do not have standing to sue for his or her injury. Citizens may not sue to prevent governmental actions unless they may suffer some personal harm. Executive Law 6312 was promulgated to give the Attorney General standing to sue on behalf of the people of New York to prevent or deter the precise type of fraud here at issue. Arguments to the contrary are risible. Defendants' arguments that the factual record developed in discovery changed the landscape under which standing should be viewed is legally preposterous. The best that the defendants could muster at oral arguments was to contend incorrectly that plaintiff cannot sue because the subject transactions were between private entities and nobody lost money. However, that's purely an argument on the merits, not an argument on standing. Taken to its logical extreme, absolutely any time a defendant denies liability, it could move to dismiss on the ground of lack of standing. Exacerbating defendants' obstreperous conduct is their continued reliance on bogus arguments in papers and oral argument. In defendants' world, rent-regulated apartments are worth the same as unregulated apartments. Restricted land is worth the same as unrestricted land. Restrictions can evaporate into thin air. A disclaimer by one party casting responsibility on another party exonerates the other party's lies. The Attorney General of the State of New York does not have capacity to sue or standing to sue, never mind all those cases where the Attorney General has sued successfully under a statute expressly designed to provide that right. All illegal acts are untimely if they stem from one untimely act and square footage subjective. Some harsh words. That is a fantasy world, not the real world. There is also a larger context to the sanctions issue. Several defendants are no strangers to sanctions and why courts are sometimes constrained to issue them. In the investigatory special proceeding, this court found Donald Trump in contempt of court and sanctioned him $10,000 per day for failing to comply with his discovery obligations. This court lifted the contempt after 11 days. The First Department affirmed the contempt and fines. Quoting here, the financial sanction to compel compliance was a proper exercise of the court's discretionary power and was not excessive or otherwise improper under the particular circumstances. In Trump versus Clinton, an order on a motion for indicative ruling, here, Judge Middlebrooks denied what in New York legal parlance would be called a motion to re-argue, pursuant to which Donald Trump asked Judge Middlebrooks to vacate sanctions imposed on him and his legal team, totaling close to $1 million. Judge Middlebrooks wrote on the first page thereof that movants acted in bad faith in bringing this lawsuit and that this case exemplifies Mr. Trump's history of abusing the judicial process. Footnote 6 here. One factor Judge Middlebrooks considered was Donald Trump's disrespect for legal principles and precedent. In short, Donald Trump and his lawyers are not sanctions nephites. This is not their first rodeo. Unfortunately, sanctions are the only way to impress upon defendants' attorneys the consequences of engaging in repetitive, frivolous motion practice after this court, affirmed by the appellate division, expressly warned them against doing so. Citing case law, sanctions serve to deter future frivolous conduct, and their goals include preventing a waste of judicial resources and deterring vexatious litigation and dilatory or malicious litigation tactics. It is of no consequence whether the arguments were made at the direction of the clients or sua sponte by the attorneys. Counsel are ethically obligated to withdraw any baseless or false claims if not upon their own review of the record, certainly by the time the Supreme Court advised them of this fact. Citing case law upholding sanctions against attorneys because counsel continued to pursue claims which were completely without merit in law or fact. Citing further case law here, affirming sanctions against attorneys upon finding there was no factual or legal basis for defendant's original cross motion or for the re-argument motion, that both motions were totally frivolous and were submitted just really to delay. Counsel should be the first line of defense against frivolous litigation. Accordingly, this court grants the AG's motion for sanctions, in part to the extent for sanctioning each of the defendant's attorneys who signed their names to the instant legal briefs. And we have footnote 7 here. The following attorneys signed their names to defendant's instant briefs and are accordingly sanctioned $7,500 each. Michael Medeo, Clifford Roberts, Michael Farina, Christopher Kais, and Armin Morian, in the amount of $7,500 each, to be paid to the Lawyers Fund for client protection of the state of New York no later than 30 days from the date of this order. So that happens. That's quite a bit. Next, arguments defendants raise for the first time. Let me just make sure I've got my... There we are, just making sure everything is in place here. All right, arguments defendants raised for the first time. So Justice Ingran had been speaking of all of the arguments that they had brought up multiple times and then sanctioned his attorneys for bringing them up again. So now we have our first time arguments set up. Again, this is the motion for a summary judgment order by Judge Ingran in the New York fraud case. All right, so here we go. Summary judgment standard. To prevail on its motion for summary judgment on all causes of action, defendants must first make a prima facie showing of entitlement to judgment as a matter of law, tendering sufficient evidence to eliminate any material issues of fact from the case. Citing case law here, failure of the movement to make such showing requires denial of the motion, regardless of the sufficiency of the opposing papers. If the defendants make out their prima facie showing, the burden then shifts to plaintiff to offer evidence sufficient to rebut that showing by identifying disputed issues of fact that should go before a trier of fact. Defendants strenuously argue throughout their briefs that the AG has not met her burden sufficient to defeat defendants' motion for summary judgment. However, defendants misstate the black letter law applicable to summary judgment. Citing the dental case here, for the flatly wrong proposition that in order to defeat summary judgment on these claims of predicate illegality, the New York AG must, with respect to each predicate illegality attached, establish each element of its cause with respect to those causes of action. So that's 2 times now that the black letter law is incorrect, according to Judge Ingran. Not only does City Dental not stand for the proposition, it merely found that under the circumstances of that case, plaintiff's evidence failed to meet her burden on summary judgment. But the law is well settled that to defeat a motion for summary judgment, the opposing party must show facts sufficient to require a trier of any issue of fact not make out its own case. Citing the Zuckerman case out of 1980, while the AG must establish each and every element of its causes of action in order to prevail on its own motion for summary judgment, in order to defeat defendants' motion for summary judgment, provided defendants are able to demonstrate a prima facie case, an opposing party must show facts sufficient to require a trial of any issue of fact. Citing the Guzman case, evidentiary facts derived from documents submitted in opposition to summary judgment motion are sufficient to present a triable issue of fact. So documents themselves are sufficient. Next up, we have the worthless clause. Does everyone remember the worthless clause? Oh my goodness. So here we go on the worthless clause. Defendants rely on what they call a worthless clause set forth in the SFCs under the section entitled Basis of Presentation that reads, as here pertinent, as follows. Assets are stated at their estimated current values and liabilities at their estimated current amounts using various valuation methods. Such valuation methods include, but are not limited to, the use of appraisals, capitalization of anticipated earnings, recent sales and offers, and estimates of current values as determined by Mr. Trump in conjunction with his associates, and in some instances, outside professionals. Considerable judgment is necessary to interpret market data and develop the related estimates of current value. Accordingly, the estimates presented herein are not necessarily indicative of the amount that could be realized upon the disposition of the assets or payment of the related liabilities. The use of different market assumptions and or estimation methodologies may have a material effect on the estimated current value amounts. So this is the worthless clause, everyone, that was written in. That is also a piece of this appeal. In his sworn deposition, Donald Trump spent a lot of time invoking this clause, quote, well, they call it a disclaimer, end quote. They call it a worthless clause too, because it makes the statement worthless. Donald Trump goes on to say, quote, I have a clause in there that says, don't believe the statement, go out and do your own work. This statement is worthless. It means nothing, end quote. Furthermore, Donald Trump implies that he did not consider it important to review the SFCs for accuracies because of the existence of the purported worthless clause. And then we have some direct quotes here, everyone. We have the AG. Does this refresh your recollection of the process whereby you would get final review of the statute of the statement of financial condition? Yeah, I think generally it's interesting. I would say as years went by, I got less and less. And then once I became president, I would, if I saw it at all, I'd see it, after it was already done. So in the period, again, I hate to be boring and tell you this, when you have the worthless clause on a piece of paper and literally the first page, you're reading about how this is a worthless statement from the standpoint of you're using it as a bank or whatever, whoever may be using it, you tend not to get overly excited about it. I think it had very little impact, if any impact, on banks. So am I understanding that you didn't particularly care about what was in the statement of financial condition? I didn't get involved in it very much. I felt it was a meaningless document, other than it was almost a list of my properties, with good faith effort of people trying to put some value down. It was a good faith effort. Yikes. Defendants further submitted the affidavit and deposition transcript of Robert Unnell, who purports to be an expert in commercial real estate, for the proposition that because of the worthless clause in the SFC, no lender relies on these for what it is. However, defendants' reliance on the worthless disclaimers is worthless. The clause does not use the word worthless or useless or ignore or disregard or any similar words. It does not say the values herein are what I think the properties will be worth in 10 or more years. Indeed, the quoted language uses the word current no less than 5 times and the word future 0 times. Additionally, as discussed supra, a defendant may not rely on a disclaimer for misrepresentation of facts, peculiarly within defendant's knowledge, citing case law. Here, as the valuations of the subject properties are obviously peculiarly within defendant's knowledge, their reliance on them is to no avail. Furthermore, this special facts doctrine applies regardless of the level of sophistication of the parties, citing case law, holding a disclaimer does not bar liability for fraud where facts were peculiarly within disclaiming parties' knowledge. Thus, the worthless clause does not say what defendant says it says, does not rise to the level of an enforceable disclaimer, and cannot be used to insulate fraud as to the facts peculiarly within defendant's knowledge, even vis-a-vis sophisticated recipients. So that is the worthless clause, everyone. Next, we'll move on to the tolling agreement. Now, the statute of limitations, again, is one of the biggest issues he's appealing on here. The First Department has declared that claims are timely against defendants subject to the tolling agreement if they accrued after July 13th of 2014, and claims against defendant not subject to the tolling agreement are timely if they accrued after February 6th of 2016. Defendants concede that the tolling agreement binds each of the LLC defendants and the Trump Organization. However, they argue that each of the individual defendants and the Donald J. Trump Revocable Trust are not bound by the agreement. Again, the exact argument that's on appeal. Alan Garten, the Trump Organization's chief legal officer, originally entered into the tolling agreement on behalf of the Trump Organization on August 27th of 2021. The agreement was extended one time by an amendment dated May 3rd of 2022. It tolls the statute of limitations for the period from November 5th of 2020 through May 31st of 2022. The agreement contains a footnote to the entity, the Trump Organization, that reads as follows. As noted in the December 7th of 2019 subpoena issued in this investigation to the Trump Organization, the Trump Organization as used herein includes the Trump Organization, Inc., DJT Holdings, LLC, DJT Holdings Managing Member, LLC, and any predecessors, successors, present, or former parents, subsidiaries, and affiliates, whether direct or indirect, and all directors, officers, partners, employees, agents, contractors, consultants, representatives, and attorneys of the foregoing, and any other persons associated with or acting on behalf of the foregoing, or acting on behalf of any predecessors, successors, or affiliates of the foregoing. Thus, the tolling agreement at issue here binds all directors and officers and present or former parents of the Trump Organization and its affiliates and subsidiaries. It is undisputed that at the time the tolling agreement was executed, each individual defendant, Donald J. Trump, Donald Trump Jr., Eric Trump, Alan Wesselberg, and Jeffrey McConney, were all directors and or officers of the Trump Organization. Defendants argue that the non-signatory defendants are not bound by the agreement, citing the Highland case, for the general principle that only the parties to a contract are bound by the terms. However, defendants fail to quote the following sentence, which provides that, quote, a non-signatory may be bound by a contract under certain limited circumstances, citing Highland. Citing further case law, non-signatory companies bound by agreement with language defining signatory to include all subsidiaries, affiliates, and successors. In People v. Jewell, in a case involving nearly identical language in a corporate tolling agreement, the First Department recently held that non-signatory corporate affiliates, officers, and directors were bound by the agreement. Similarly, here, all the individual defendants are bound by the instant tolling agreement's terms and may be held liable for any claims that accrued after July 13th of 2014. We do have footnote number 8 here, which states the subsidiary similar tolling agreement at issue in Jewell can be found under this index number. So we have a citation there. Defendants argue that the AG is judicially estopped from asserting that the agreement binds the individual defendants based on the statement the AG's counsel made during oral argument in the investigatory special proceeding. Specifically, on April 25th of 2022, while seeking to hold Donald J. Trump in contempt for failing to comply with court orders, the AG's counsel stated, quote, there's a hard prejudice because Donald Trump is not a party to the tolling agreement. That tolling agreement only applies to the Trump Organization, end quote. For judicial estoppel to be applicable, first, the party against whom the estoppel is asserted must have argued an inconsistent position in a prior proceeding, and second, the prior inconsistent position must have been adopted by the court in some manner. Citing the Bates case. Defendants are correct that the first prong is satisfied in the statements the AG's counsel made during oral argument are consistent with the position the AG is now taking. However, defendants cannot demonstrate that this court adopted the prior position. Indeed, the court did not need to, and it did not consider the tolling agreement when it issued its April 26, 2022 decision and order finding Donald Trump in contempt. Citing further case law. For the doctrine of judicial estoppel to apply, there must be a final determination endorsing the party's inconsistent position in the prior proceeding. This court has not addressed the tolling agreement until now. Accordingly, defendants cannot demonstrate that this court adopted the AG's prior inconsistent position. Moreover, the party asserting estoppel must show, with respect to himself, 1, lack of knowledge of the true facts, 2, reliance upon the conduct of the party estopped, and 3, a prejudicial change in his position. Here, none of the defendants claim that they changed their positions or course of conduct in reliance upon the statement of the AG's counsel during oral argument. Finally, while judicial estoppel may be applied to prohibit inconsistent changes in factual positions, courts have declined to extend the doctrine to changes in legal positions, citing case law, finding there's no legal authority for broadening of the doctrine to include seemingly inconsistent legal positions. Who physically signed the agreement is a question of fact. Whom it binds is a question of law. Defendant's argument that the DJT revocable trust is not bound by the tolling agreement falls flat. In his deposition, Donald Trump affirmed under oath that the assets of the Trump organization are held in the DJT revocable trust, for which he is the sole donor and beneficiary. Donald Trump also affirmed that at the time the trust was formed, he was the sole trustee and remained the sole trustee until 2017, when the defendants Alan Wesselberg and Donald Trump Jr. became the sole trustees. As every beneficiary, donor, and trustee of the DJT Revocable Trust is a defendant bound by the tolling agreement, and as the trust is unquestionably a parent of the Trump organization, so too does the tolling agreement bind the DJT Revocable Trust. Citing case law here, it may likewise be inferred that the trustees had knowledge of the activities of the businesses they controlled through the trust mechanism. Hence, under Executive Law 6312, the family trusts and trustees may likewise be held liable for fraud. Citing Kuzman, courts will not allow the owner of assets to evade creditors by placing the property in a trust while retaining a right to revoke the trust. Defendants cite the New York Estates Power and Trust Law for the proposition that only a trustee may bind a trust to an agreement. However, this law does not state this. Rather, it states, B, in the absence of contrary or limiting provisions in the court, order, or decree appointing a fiduciary, or in a subsequent order or decree, or in the will, deed, or other instrument, every fiduciary is authorized. And subsection 17, to execute and deliver agreements, assignments, bill of sale, contracts, deeds, notes, receipts, and any other instrument necessary or appropriate for an administration of the estate or trust. This provision simply says what a fiduciary is permitted to do in the absence of a contrary provision. It does nothing to advance defendants' arguments that only a trustee may bind a trust, particularly since defendants failed to cite to a provision of the DJT revocable trust restricting who can bind it. As Section 11-1 anticipates, moreover, the Korn case upon which defendants inexplicably rely is irrelevant to the instant analysis, as that case involved an examination by the court as to whether a fiduciary. Sorry, everyone. Hold on one moment, please. Sorry, everybody. There we go. All right, we are verified. Phew. All right, where were we? All right, we'll just skip to the next one. Finally, the Attorney General should not be limited in her duty to protect the public interest by an agreement she did not join. And then we're citing further case law here, the Coventry First case, holding the Attorney General is not bound by arbitration agreements when pursuing Executive Law 6312 claim, and finding such an arrangement between private parties cannot alter the Attorney General's statutory role or the remedies that she is empowered to seek. The tolling agreement was a mutually beneficial and common arrangement pursuant to which the AOG agreed to hold off suing, and Alan Garten, on behalf of the Trump Organization, agreed to toll the statute of limitations. All defendants received the benefit of the bargain. The AG held off on suing. The AG is entitled to the benefits of the bargain, the tolling of the statute of limitations for the limited agreed upon time. As against anyone, it could have sued for the matters at issue at the time at which the agreement was executed. The AG clearly did not intend to permit defendants' principals to evade the tolling agreement based on a technicality contrary to the spirit of the agreement and controlling case law. And with that, everyone, I will go ahead and pause. We are pausing halfway through the order here on that summary judgment order for Judge Ingron, so I can do questions for just a little bit here. We'll do a Q&A. I will finish the second half of this order at a little bit different time, but I do want to go ahead and do questions at this time. So hold on. We've made it through the big questions at this point. So hold on here, everybody. Okay, comments on. Hello, everybody. Hello, welcome in. So we've done the first half of the motion, or the order here on summary judgment, everyone. Hello, welcome in, everybody. Welcome, good to see you all. Good to see you. I think sometimes we forget all of the details that are really involved in this case. It's actually a very, Justice Ingron did an amazing job really setting out every single fact and every single piece of law in here. So he did a very good job writing both of the orders, I thought. Good morning, everyone. Hello. Good morning. No problem, Kaya. So I am trying to post all of my lives as soon as I can up on my Tube of You. So I should have this up as soon as I can within the next couple of hours. Oh my gosh, yes, to all of the gifters, thank you so much. Sometimes I catch it when I'm reading a document, but sometimes I don't. So I apologize if I didn't catch your gift, but I thank you very much for that. The toner paper situation gets dire here. Yes, Brian, I've been going a little bit earlier recently, especially with the a convention going on right now. I'm finding it a little bit easier to kind of do it a little bit earlier in the day right now. Any word on the documents case? Not as of right now. We're still kind of waiting for different responses. There is, let me grab my calendar here. It looks like the next filing that's due, I believe this is a Florida case. I didn't highlight with a color, and I should do that, but I believe next week we've got a government brief due. So we should hear by the beginning of next week something on that at this point. But that will not be until next week. But I'm very anxious to see what the government has to say about their appeal on that. It's possible to be sanctioned. It's absolutely possible. Absolutely. So, good. I'm glad. No, this is not a new document. We are reviewing the decision and order on the summary judgment in the civil case in New York. So what's happening right now is that this New York civil case, everyone, has been appealed by Mr. Trump. He has appealed this order that I'm going through right now, as well as the final order by Judge Ingron. So he's appealing both of them. And we've got the government's response to that appeal. The response brief is due tomorrow. So this is kind of prepping for when their filing comes in. So we should have a new filing on this case anytime now. So I'm kind of setting you up here, setting you up for the next filing that we should be getting. Yeah, we're definitely in an appealable. We're in the appeal zone. We're in so many appeal zones, everybody. Everything's being appealed. And this case has just been, it's been going on for a very, very long time. So we just continue on. They truly believe what they presented. I don't think so, because of how many times they had been warned. The judge had told them over and over and over again. This was the third time they were using the same arguments that the judge had already told them were frivolous. So they knew it. They just continued to do it anyway. So I think they're pretty well informed of the situation. Be easier to say what he's not appealed. True, actually. And that would be the blessing game case to the Supreme Court that I know of. How many appeals does he get? So, great question. And, our court system, with how the system works, right? You have your trial court, and then you have your first appeal, all right? Your first appellate court, whatever it's called. And then you have your last appeal, which is your Supreme Court of whatever your Supreme Court's called in your state appeal. So this is state versus federal, all right? So if it's a state case, which is what we have here, he has his trial, and so what he's appealing right now is his first appeal. So we're only on his first appeal, and then the top court in your state, you can have one more appeal. So you get two levels of appeal. Is really what you get. Now, the number of appeals depends on the number of issues that you've got going on and how you want to kind of strategically place your cases. So that's kind of a little different issue. Thanks, Thomas. Abusive system, at what point does it stop? Great question. And, it would be inaccurate to say that Mr. Trump has not had a significant effect on our legal system. We're definitely going to be going down in the history books here, and hopefully it won't be trending, but of someone who is using the system in this manner. And it is just, yes. So it's a pivotal moment in our legal system, in our whole legal world, where we are seeing how someone, as long as you've got enough money to hire the attorneys, you can really keep these appeals going on and on and on. So at least we're shedding some light on it, but hopefully others with the resources won't continue to do what they're doing. But I don't know how to make it stop at this point. We're kind of set up for that. Trump's legal history. Oh, true story, Dawn. True story. I'm still putting together the cases of Mr. Trump. I will be continuing to post, but there's just so many. There's so many lawsuits. So many. What's the cost? Yeah, it's. I would have no way to figure it out. The appeal costs. The appeals aren't that expensive to work on as long as you don't have a huge judgment against you. So that's kind of the thing. Jenna Ellis flipping significant. I think anytime anyone on any of these cases flips, it's significant. I think definitely it's a huge help. It could be a whole degree program. Oh, I know. Taught as a 101, what not to do. Oh, I know, it's a lot. Yeah, it's a lot. Unfortunately, it really is. It's really, it's too much, everyone. It's too much. Oh my gosh. And, as I had said yesterday when I had popped on, these cases the civil cases are going to go and go and go and go forever, on and on and on. What he owes with all of his lawsuits. I'm sure someone is. I'm working on it myself right now. So I am hoping to kind of do one big overview. But, there's just so many, everyone. There's so many. There's just so many going on. So It's hard to kind of keep track. I do have the lawsuit against ABC Stephanopoulos. And that one I will be doing over on my Tube of You channel, because I won't be able to, the censors over here I won't be able to do a full analysis of that. But I'll make an announcement when I do that case, and that one will be over on my Tube of You. But I'll have to wait a little bit to do that one. I'm kind of having to space things out a little bit here. Have you heard anything about Mark Meadows lately? Yeah, he filed his writ of certiorari. Actually, we've got his writ of certiorari was filed in the Supreme Court, and actually, D.A. Willis's response to that is due next week. So we should hear a little something about that. So he's still moving and shaking with his whole, I'm federal within the scope of my job questions. So we'll see how that shakes out in the end. But, oh, absolutely, you're very welcome. He delays to get them to drop them. Oh, he really does. He really does, everybody. And I was just looking through, because there are so many lawsuits, just reading through the Summer Zervos case, which was, it's a heartbreaking case, everyone. This was another lawsuit where she had filed, but had gotten to a point where she just couldn't take it anymore. She just got burned out and stipulated to dismiss the suit. So this lawsuit was, again, heartbreaking, and based off of her complaint, it was pretty significant, but she just got to a point where she didn't want to deal with it anymore, and I don't blame her. So I don't blame her one bit here. So you can take a look if anyone is interested in what her case was. So I'm only really reporting on the cases that are ongoing, that have not just been dismissed. So I won't be covering her case, but yowzers, everybody. This is another assault type case that came out. It's pretty bad. Have you checked on Rudy lately? Nope, not that I know of. The last thing I heard was her counsel pushing for the dismissal of the bankruptcy case in New York a couple weeks ago for Giuliani. So her attorneys are working hard, so I do know that. Oh, you meant Rudy. I'm sorry, I thought you said Ruby. Rudy, yes. So Rudy's bankruptcy got kicked out of New York, so he's no longer allowed to file his bankruptcy. So he's got to go forward on that. So right now they're kind of renegotiating, and I'm betting he's trying to figure out how he's going to pay stuff off now that they're not allowing him to file a bankruptcy case. So there you go. You got a Ruby and a Rudy. That's a twofer. Oh my goodness gracious. So it's a lot. But with that, everybody, I am noting the time, so I will go ahead and sign off for now. Again, I'm just, thanks for being so flexible with me for the timing on this. It does seem to be working better for me to kind of come on a little bit earlier in the day rather than in the evenings right now. So I'll continue to do that. I will hope to come back on again as soon as I can. I will continue to monitor all of these cases, everyone, and as soon as we get a new filing, I will make sure to come on live and read through that filing. So right now we're just kind of doing a little bit of history here so that we're prepared for the filing that is coming out, that is due in this case. So with that, I will go ahead and sign off. Again, thank you all for joining me. I really appreciate it. Thanks for hanging out. I will keep you... Eliza, yeah, I'm struggling a little bit. That's why I've got to kind of keep my time down. So, unfortunately. But I will keep you informed of any of the new paperwork that comes out, any of the new things. So just make sure you've got your announcements on, everyone. And I will try to come on around the same time each day. But again, it just really depends. But I appreciate your flexibility. So take care, everybody, and have a wonderful rest of your day. And I will catch up with all of you very, very soon.